Assalamualaikum, Sastakar, Namaskar to all the listeners. This is Attorney Shapur Ali, and today we are going to talk about immigration law. So many things happening, and of course, anything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. So I'm going to talk about two important issues, then we're going to start taking calls. For one, we have this public charge rule that comes into effect because the Supreme Court has kind of validated it now, unfortunately. And I'm going to talk about that. But I'm also going to talk about the famous thing that is affecting everybody, the coronavirus, not in the medical terms, but how it can affect your immigration. So I'm going to talk about those two. But let me start with the coronavirus because that's not going to be long. One of the requirements of admissibility in the United States is that if you don't have a communicable disease. And since the coronavirus is a communicable disease, we don't know how long it lasts and things like that. I am expecting that it might be used for, in some cases, to deny benefits. But according to most experts at this point, and we don't even know who's an expert now because the different opinions are coming. It's only 14 days incubation, so those 14 days you might not be admissible in the United States if you have you're detected with the coronavirus. But it's a long shot, but I just wanted to mention it because there is a provision under the law that you are inadmissible if you have a communicable disease. For example, if you have a STD and things like that, so that can affect your ability to enter the United States. So just as a footnote on that, but of course this is really a big thing. It seems the coronavirus, the entire China is crippled. So and other countries now affected. Many countries don't even know they are affected, and we pray for them. Hopefully they're going to come up with a vaccine because this is very worrisome and scary. And hopefully today I have Vedika with me on the board, and we are going to discuss about other issues on immigration law. Now the big thing that happened is that issue of public charge. So if someone is filing for an adjustment of status or a green card, and that person has been found to have used certain public charge, and I'm going to list some of them they have used those benefits for more than 12 months, within 36 months, it can be considered as a public charge. So I'm going to go over this, and we're going to go into more details probably in the next shows, but right now I don't have that much information. You can call if you have any questions, of course. The studio lines will be open like in 10-15 minutes because I have to go over this. 510-657-1170, that's the number to the studio. And if you want to do a private consultation or you want any help, give us a call. Even if you want a second opinion, at 510-742-5887. 510-742-5887. And as I was mentioning earlier, we're going to see a standstill. It seems like pretty much entire China is affected, and it's spreading to its neighbors. So we might see a real huge reduction in immigration due to this, because it might be a reason that people can be denied, or you won't even have flights. And U.S. embassies abroad will also be affected. Probably if a region is affected, you might have a U.S. embassy basically kind of closed, and you won't be able to do your interview, etc., for your stamping. So I kind of jump from one to the other, but the reason for that is that I forgot to omit that. So watch out, and then subscribe to my YouTube channel. I'll try to update you as we go. youtube.com/ShapurAliLaw. And make sure that you follow up on this, because that can create some issues. I'm pretty sure China, many places, the U.S. Embassy will be closing because of this situation. So let's wait and see how things unfold, but be ready for this stuff. And hopefully these things will go away. Well, hopefully, God knows. But this is going to be the news of the next 2-3 months now. And of course, we have all the things happening in the Middle East. That's going to be another news, and plus the impeachment. But this doesn't really affect our immigration, so I'm not going to talk about them. So now let me go back to the public charge issue, that rule that was on October 11, 2019, but which was held by a federal court, and then it went to the Supreme Court, and the Supreme Court, of course, now rubber stamping pretty much everything. They are going ahead and saying no, it's okay to have it. And this is going to affect a bunch of people, because many people, especially the elderly, they ultimately, when they come to the U.S., they of course take advantage of the system, and that can affect people to get their green card. These are people who are applying for a green card, not people who already have a green card, by the way. So you need to distinguish that. And one of the things that people don't realize sometimes is we come to the United States, we don't take any kind of provisions, and a lot of people have been using actually benefits, not realizing it, or the hospital themselves just put them on those benefits. And now, based on that, they might be denied a green card. And they say it's not for everybody. They might, because they say on a case-by-case basis, they can consider giving it to them. So, for example, someone they don't like, they won't give it, quote unquote, I'm just saying, but someone they think, okay, has a good case, sorry for that, I should not say they don't like, someone they don't feel has a strong case, why they should have they have used the welfare, they will ultimately get a denial. So, Vedika, just letting you know, if in case there's any call, please let me know. But the number to the studio, 510-657-1170. 510-657-1170. And again, this is Attorney Chaparral, and while live today is the last show of the month. Today is January 30th, 2020. Oh my God, time is going so fast. The month is already ending. It just started. I still remember we just were celebrating New Year. And this year has been full of things, right? And as you see, since the beginning, we have been seeing earthquakes. We have been seeing almost tsunami yesterday, or the day before, and things like that. So it has been a charge year. Plus now we have this thing hitting us on the public charge, making people inadmissible if you use certain benefits for more than 12 months within the 36-month period. On a case-by-case basis, the USCIS will determine if they want to give you your green card or make you inadmissible. So this is big, because there was a lawsuit that blocked it. Now the Supreme Court, of course, released it. As I said, the Supreme Court is mostly becoming a rubber stamp now. I'm sorry to say that, but this is what's happening. So what is a public charge is basically, as I explained it, if you are using U.S. government welfare and you have used it for more than 12 months within 36 months, it can be construed as a public charge. Doesn't mean for everybody it is a public charge. Things that they are going to consider is probably age, health, your family status, your assets, resources, and your financial status, education, skills, etc. So the factor that the thing that they're going to use to determine that is the Affidavit of Support. As you know, there's a form for Affidavit of Support, and that's what they're going to use. And also, you'll have to prove. Now, this is the part which is tricky. The person who's being petitioned themselves will have to prove they can take charge of themselves, and that's the part. Can you hear me properly now, Vedika? I heard that there was some kind of... Okay, perfect. I apologize for that. So let me speak closer to the microphone. So the thing that is kind of a little bit tricky and worrisome, well, all of it is kind of worrisome, but the part which is worse is that when it used to be, for example, you sponsor for your spouse, and your spouse doesn't have a job, doesn't have any income or anything, that's fine as long as you're making the income. But in this case now, it seems like the person also has to prove that they are making the money. And I know someone called, I think, last week about this, and I said, well, so far it has been blocked, but unfortunately it's got unblocked now, so get ready for that. And also they are talking about the general assistance. So public charge programs are cash for income maintenance through supplemental to SSI, for example, TANF programs, state or local cash programs for income maintenance. We are talking about food stamps here and things like that. So all those things were already there, kind of. They just made sure now it used to be that the petitioner had to repay for that, which they never did, of course. But now they're taking it to a higher level, and the higher level is actually the part of denying you a green card. So at this point now, when you're filing for your adjustment of status, no matter what kind, employment-based, family-based, yeah, you name it, U visa, etc., make sure you talk to a lawyer and file it, and make sure that a good case is prepared to explain in a situation if this is a public charge or not. Because if you're just going to submit it like that, they might not even, they might deny it. But if a good explanation, a good analysis is done, you have a chance. And the reason for that is that they say it's going to be a case-by-case basis. So you need to be of course, careful about that. There are some exceptions to that. For example, Medicaid and health insurance, those you have used for short terms. If you have used support for long-term in institutional care, that can be a problem. But short-term, it won't be a problem. Short-term has been less than 12 months usually. Children health insurance program and nutritional programs, assistance program, etc. Housing benefits, some child care services, energy assistance, like low-income program, emergency, disaster relief, foster care, adoption assistance, educational assistance, job training, non-cash benefits, cash payments, unemployment compensation. Those are not under this. This is what it says, but I'm going to analyze it further. So you need to make sure that if you are using any other things in the United States and you're filing for a green card, you might see yourself into some major issues, and you will have to deal with that. So again, ladies and gentlemen, this is Attorney Chaparrali. We'll be opening the lines now if you want to call 510-657-1170. 510-657-1170. Now, the big question a lot of people are asking me is the California covered the Obama program. Well, that's technically an insurance. So I don't know if really they're going to use that against people, but they have ways of kind of, like it says, it might be so they might be trying to use that against the people to deny them basically a health insurance. Anyway, the Obamacare program was not meant for people. If you're a green card holder, I think you're eligible for it. But if you're not a green card holder or you're a citizen, I don't think you're even eligible for that. For those who have used that, then you have a different issue. So you might want to check how come you got that when it's not supposed to be for non-citizens or non-green card holders. So that's the answer on that. Is it an inadmissibility issue? Yes, it might be because you are not supposed to use that program. However, the program itself, it doesn't have any issue in that. Now, the other things is that for those who already have a green card and they basically get those benefits legally because they're green card holders, then they are not subject to this public charge rule. These are for people who are applying for a green card. I repeat that. These are for people who are applying for a green card. So it's important you know that. So I think we have one caller, 510-657-1170. That's the number to call. This is Chaparrali. You're live on air. Hello? Hello?
Hello? Hello?
Hi. Yes.
Hi, this is Harsha.
Hi, Harsha.
Hi, actually I have a question regarding my immigration. I have a green card, conditional green card, and me and my husband both filed Form I-751 jointly, and soon after that my husband filed a divorce. It's 2 months later he filed a divorce. So, I'm in the process. I have not got any bifurcation or any decision for the divorce yet. So I was curious, what should be my next step? Should I notify USCIS, or I should wait for the bifurcation, or what should be the next step from now?
Okay, that's a very good question. Okay, whenever you file a joint petition and then there's a divorce, you're supposed to notify USCIS ASAP. However, what you need to do, you need to ask them to convert it into what we call a waiver, I-751 waiver. And it's at their discretion actually to convert it, but usually they do. And then what you need to do, you need to get your divorce ASAP completed. You have 90 days from that date when you notify them technically or file an I-751 waiver to finalize your divorce. So it's a tricky situation. Should you advise them or not depends on your case. So the best is I cannot ask you private questions on the air. So maybe you can give me a call and I can guide you what you need to do next. But yes, to answer your question, yes, you have to notify them. There was a memo on that specifically, and at the same time, you need to get your divorce ASAP, because to get the I-751 waiver based on a good faith marriage, the divorce has to be finalized. Okay?
Yeah, that's because it has not been finalized yet, and okay.
That's why you need some time and then get that, because once it gets converted into an I-751. But having said that, now let's say they deny it, you still can file an I-751 waiver, okay? Because that's normal. For I-751 waiver, there is no deadline like the joint petition, okay? So give me a call and we can discuss in more details the dates and the strategy on your case, because I cannot ask you private question on the air, and I have to ask you, okay?
Yeah, but because I am the petitioner for this file, can my husband withdraw the application?
Not really. Well, if you put the I-751 waiver, you inform them already, then no, he cannot really, because he doesn't have control over it. But if he's abusive, that's a different issue also. That's why I wanted to talk to you privately, because it's hard to ask you this question on the air. Okay?
Okay. Thank you. Thank you for your help.
You're welcome. 510-742-5887 is the number to our office. Let me take another call, Vedika. This is Purali, you're live in air. Hello.
Yeah, thank you for taking call, Shah.
You're welcome, sir. Go ahead.
Yes, I have a question. I'm applying for H1B and H4 extension, and along with that, I came to know that I can apply extension for EAD. So in that form, they are asking for the I-94 and the expiration date. So should I put the old I-94 and expiry date in that?
No, hold on. You mean on the application, right?
Yes.
Of course, you have to put the old one, because you don't have a new one
along
yet.
with the H4 extension.
Yeah. You don't have a new one yet, so you have to put the old one.
Oh, I see. Okay, so that should work. Okay.
Yeah, that's all you have. You cannot put anything else. That's what they're asking, because if there's an extension, then... In fact, this is a good question you just asked. Whenever people file an H1, H4, file also your extension if you're eligible for the extension. Okay?
Can you please repeat that, Shah?
Okay, I was just mentioning that this is the rule. Whenever someone is filing an H1 and they're filing an H4 extension, they can... Okay, I lost the caller, but let me repeat the answer. If someone files for an H1 and they're filing for an H4 extension, take advantage of it to file your H4 EAD, because otherwise, if you file it later, then it becomes more complicated for the USCIS to process the case. But if it all goes together, they will know where to send it and process the H4 in its department, H1 in its department. So that's all I was saying. So just to remind people when they're filing, of course, the EAD has to be eligible for renewal, and you can renew technically 120 days, but they kind of allow people 180 days before to submit it. Okay, so I think I have another caller, right, Vedika? This is Shapra, you're live in here. Hello? Okay, I don't have any callers, so feel free to call. The lines are open. 510-657-1170. 510-657-1170. Our website piralilaw.com or attorneyonair.com. Attorneyonair.com, and you will route you to the same website. And again, I wanted to say thank you for the listeners for listening. This is at the end of the first month of the year. Like I said, it went really fast, and so many things happened this month. For one, we have this public charge situation which I was talking about, and also we have the coronavirus. All this can really kind of create more problems on immigration. So let me take another caller. This is Shapra, live on air. Hello.
Hi. So I have a situation related to my wife's H-1B visa. So what happened was last year she got in 2018 she got her visa extended, and her I-797 was given till 2021 January. So when she went for stamping last year, she got the stamp date as January 2020. But then we submitted it for correction, and then it got corrected, and the new date was Jan 2021, as it was matching to I-797. But she got a call from her HR and attorney yesterday, from her company HR and attorney yesterday, saying that as per their calculation, she is eligible only to work till March 2020, and she will be finishing her 6 years in March 2020, and it's a mistake from USCIS that they gave it till Jan 2021. So does that really happen?
Yes, you're right. There's a case law which says if USCIS make a mistake and you kind of quote unquote took advantage of that mistake, you're responsible. So your attorney is right. Once you reach the 6 years, she's supposed to stop working. Even if you look at the 797, it says for a longer time. What needs to be done, she needs to shift to another visa. Maybe if you have an H1, she can do an H4, and if you have an I-140, do an H4 EAD. So I recommend she doesn't pass the March date, because if she does, she will be unlawfully working, and later on when it's time to file for her green card, it will be a headache for you. Okay?
So I recently filed her H4 and H4 EAD, but we haven't got the receipt yet. So what should be the case? And we are really confused right now. It's like, can we expedite the H4 change of status, or she has to go to India and get the visa stamp?
No, you cannot. One of the ways to get the H4 EAD fast is travel outside, go and get the H4, and then when she comes back, you refile a new EAD for her. But there's no way to expedite it, especially you just file it. If it was delayed for a long time, I would recommend trying to talk to your congressman. But this one is not a situation where you basically they delayed you file late, so that's the thing. But expediting it, the only way, if you want, you can try to talk to a congressman or a congresswoman, of course. You can just go online, type "find my congressman," and type your zip code. They will tell you who is your congressman. But
sorry, find my?
Won't do much because, yeah. Hello.
Yeah. What is that? Find my?
Find my congressman or find your congressman.
Okay.
If you Google it, it will be a website. You put your zip code, you will know who is your congressman, either the Senate or the House of Representatives. You can ask them if they can help you. There's another way to expedite it if there's some kind of hardship, but the hardship has to be extreme. Like, for example, she's sick, she needed to work, or something like that. These are the only time that they allow this to happen earlier. But right now it's taking almost 6 to 7 months to get it. Like the other option I told you, she can leave the country, file an H4, get an H4. I'm sorry, I think it's going lower, the voice. So you can also go outside, file an H4, get an H4 visa, come back in, and then when she comes back in, you can refile for a new EAD. if you want any help, like a personal guidance, give me a call at the office. We can do a consultation. 510-742-5887, and I can get you some more options if possible. Okay?
Okay, cool. Thank you.
Okay? Back to you. So, ladies and gentlemen, this is Attorney Chapter Ali, and we are live today, and we have another, I think, 10-15 minutes to go. It's going pretty fast today, and we are talking, of course, about immigration law, and the big news is, of course, the coronavirus and inadmissibility I was talking about. There is a rule which makes you inadmissible if you have a contagious or basically a communicable disease, but the fact that this is new, they have not really applied that. So, and I'm going to go ahead, and I was talking about those two, and the public charge issue, where who is a public charge, who's not, depending on the age, the totality of circumstances, if you have used it for more than 12 months, etc., etc. If you want us to assess for your personal case, feel free to reach out to our office, 510-742-5887. 510-742-5887. Since I don't have a lot of time, let me talk about another area of practice we handle cases is debt settlement, because a lot of people find themselves in debt, and now more than ever, things are not going to do well. We don't know. With all the things happening in China, happening in the world, we might see some kind of not recession, but some kind of downturn coming up. And because of that, we are expecting probably house value might go down, credit cards loans will increase, people will really use a lot of the credit card, etc. So if you are overwhelmed with debt, for example, you owe a lot of money on your second mortgage or on your credit card, we can negotiate those for you without you having to go through a bankruptcy route. And what we do, we talk to the collection agency, to the other banks, to the lawyers who are going after you, etc. In terms of collecting a debt, we can negotiate with them and get it to a lower price for you, and then you ultimately get out of the debt, because what we do is a settlement, not a debt consolidation. Remember, those are two different things. One is a debt settlement, the other one is a debt consolidation. The difference between the two, a debt settlement is a settlement. It's like, for example, you owe $15,000. We negotiate with them. We say, hey, we will pay you only $5,000, and you pretty much completely dismiss the rest, not writing it off or sell it to another creditor. But once we sign a paper with them, when we negotiate, it's like a new contract. So it kind of saves a lot of people their difficulties. But you need to make sure whenever you have a situation like you have a hardship and you're using a lot of the credit cards, we can help you get rid of them. We can also help you on Sba loans, right, for closed businesses. A lot of people have taken loans for their business, and then suddenly the business flops and they can't pay this Sba loan. Those Sba loans are these are backed by the government. That means if you don't pay them, it's almost like a tax issue. They don't even have to go to court really to start collecting. They will just go ahead, put their hands directly in your bank account, what we call levy the bank account, put lien on your property, etc., etc., and we can help you get out of those and avoid you a bigger headache. So also one thing we are expecting, hopefully it will not happen, but we are expecting some downturn coming this year. And now with all the things going on in China, it can have two things can happen. For one, you can have a situation where, because China is kind of quote-unquote crippled, it might turn out to be good for America in terms of the economy. I doubt it, but it might. I'm just saying that because many companies have a manufacturing in China, and if their manufacturing unit is kind of dead, then guess what? What are they going to do? And that can negatively affect also the economy here in the U.S. And again, I'm not an economist, so I'm just analyzing according to what I know. And I recommend that you make sure that you at least have some kind of ways to get out of those debts. For example, let's say we negotiate for you, and you for $10,000 you owe $10,000. We negotiate, they say $3,000. We have to pretty much kind of work with them and ensure this. So we can help you. We have done a lot of cases and we are getting a lot of approvals. So I recommend that you give us a call, 510-742-5887. 510-742-5887. And immigration, unlike immigration law, we don't charge anything in advance for the debt settlement. We work on a contingency. So if we get a deal for you, then only then we will charge you. So check it out. We have a blog for it. It's called yourdebtsettlementattorney.com, yourdebtsettlementattorney.com, and we ultimately can help you any way we can. I don't know how much time is left. I think it's like 12 minutes or 13 minutes. I made a mistake earlier. So feel free to call. The studio lines are still open. We had some very, very interesting questions today. 617-1170, right? No, 517-1170. So we will be glad to take your call. I keep missing the numbers now. So many numbers. I think it's 617. 657. I'm sorry. 510-657-1170. 510-657-1170. 1170. Please call if you have any questions on immigration. If I could guide you or help you, I'll be glad to do so. Now, if you want a private consultation, you can call our office, 510-742-5887. I also recommend that you subscribe to our YouTube channel, youtube.com/SharpRallyLaw. We have two actually, but the main one is Sharp-Raleigh Law, like my first name, last name, and then LAW. And also, I wanted to mention that I think we have one caller, right, Vedika? Let me take the caller. This is Sharp 11A.
Yeah, hello. Hi, this is Sonia. I have a question for you regarding immigration. I'm planning to file a green card for my brother, and he is currently having a visitor visa. So wanted to know if his visitor visa will be cancelled, or will he be able to travel in U.S. while his green card is in progress?
Excellent question. I wanted to talk about this last week. I forgot, but good you're bringing it up. The answer is it depends, okay? If you look at the letter of the law, once you file the I-130, there is an immigrant intent which comes into play. And when you have an immigrant intent, that means basically you cannot, if you travel, they have a right to refuse you entry at the port of entry. In my years of practice for siblings, I have never seen them blocking any sibling because the petition takes so many years, so he doesn't really have an immediate green card. So the B1, B2 is usually easy for them to get in. Having said that, now things are changing a lot and they're becoming more strict. So if they want to apply the letter of the law telling you that, hey, you already have an I-130 file for you, as such you have an immigrant intent, we won't give you what we call we won't let you in. And if they don't let him in, they might put him in deportation and he's stuck for 5 years. So the simple answer is usually no, but they have a right to do it. Okay?
Okay. Thank you.
Okay. Good luck to you. So, ladies and gentlemen, I think I have another 10 minutes or so to go. So, you can still call the number to the studio, 510-657-1170, and this is Attorney Sharp Raleigh for the Sharp Raleigh Law Show. I have Naz Vedika with me on board. Thank you so much for being here. And also we wanted to I wanted to talk about the opening of the H-1B season. This is coming soon. They are going to have the pre-lottery registration as from March 1, which is kind of the last minute, but they're going to do that. And if you made it to that part, then you can actually file your H-1B and things like that. So it is important that you make sure that you have a good understanding of the whole situation before you move forward. I think we have one caller, right? This is Shapra. Yeah? Hello? 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 Okay, I think I lost the call.
Hello?
Okay. Oh, hello, this is Shabra. You're live on air.
Hi. I have a question for if we have applied for our siblings and, it takes like 14 years and now they're able to come here. Their case has been approved. What about the kids? Because now they're over 18 years.
Okay. As long as they don't pass 21 plus using the Child Status Protection Act, you can add a few months. They can still file because they are they didn't really kind of pass the what I mean is you didn't pass the age out time, which is 21 years old. And plus, if they benefit from the Child Status Protection Act, you can subtract the time it took for the first part of the case, the I-130, to be approved. For example, let's say it took 1 year for the I-130 to be approved, and when the child reaches the interview, he's just close to 21, and then if you subtract that 1 year for the I-130, you can actually get what we call a Child Status Protection Act, and you can actually get their green card. So it's a little bit some calculation, and if you need help on that, give me a call, 510-742-5887. We might be able to handle it for you. Okay? Hello? I think I lost the caller. So ladies and gentlemen, this is Attorney Sharper Ali for the Sharper Ali Law Show. Today is January 30th, 2020. It's almost the end of the month, which is kind of amazing. Time is flying. I don't know if it is flying, but it's going pretty fast. And I wanted to mention also that today the topic was, number one, the issue with the coronavirus. Does that make you inadmissible to the United States? The answer is probably yes, but there are many other issues they have to deal with first. So it's something that can affect you. And number two, we were talking about the situation of the new rule, the public charge rule, which is making people inadmissible to enter the United States. And I have listed earlier many of the situations that we are seeing now. So be very, very careful and vigilant. Make sure that things are being done properly for you. If you're filing a case, have a good lawyer work on it. Otherwise, don't trust any non-lawyer to work on those cases. So I wanted to let you know that I think we have one caller, right? Let me take the caller. This is Sharp 11 here. Hello? Hello?
Hello?
Hello, hi.
Hello?
Hello. Yes, go ahead. I'm listening to you. This is Sharp.
Hi. So I had a question regarding my H-1B visa. So actually, I got my visa approved last year in December, and that time I was in India. And day before, I had gone for H-4 stamping, and I got it stamped. So when I entered US, I entered on H-4 visa itself. So of course, my I-94 got updated. So now, is there a clause that I need to wait for 90 days before I can apply for change of status from H-4 to H-1?
No, there's no rule because H-4 is a dual intent visa. So, did you enter by mistake on H-4? Or you didn't
No. I got my H-1 visa approval late,
And before that, I had already applied for H4 visa because I was not sure if I'm going to get my H1 approval or not.
Oh, okay.
So I had applied for H4 anyways. So I got it stamped before, and then I was not getting an appointment for H1, like within the days when I was there, and I had to enter on H4 itself. So earlier when my employer filed it, he filed it as a change of status itself. So now because my I-94 got updated again, so I don't know like if we can file it directly, the change of status, or I need to wait for some period of time and then only we can file it.
No, technically you don't have to wait because H4 is a dual intent visa. That means you can even file for a green card with it. Having said that, there might be other issues that will come into play, but that one is not going to be an issue.
Okay, so there's no clause of waiting, so I can just go ahead and file the change of status any day.
Yes.
Okay.
Okay.
Thank you.
Good luck to you. Good luck. You're welcome. So, ladies and gentlemen, I don't know, we have one more call I can take, otherwise we're almost done with the show. I think we have 2 more minutes to go, right? And Amit will be taking over, hopefully. I don't know. If he's not, then we will continue the show. So I wanted to talk about all the issues we are seeing all the time now. How do you deal with the situation we're having in China? And I think we have one more caller. Let me take one last caller. Chapter 11 here. Hello? 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 Hello?
Hello.
Yes, hi. This is Shah. How are you?
Yeah, hi. This is Vivek. My question is not directly related to the H1 processing or anything. My question is related to the Social Security. That people, when all the people on H1, they get the Social Security being deducted from their salaries, and that now my question is, after, like I heard that even after 10 years, and somebody leaves the country on H1 status and doesn't have a green card, he doesn't get to have the Social Security paid back when the time comes, like after retirement, age 65 or something. Is that right understanding?
Yes. Unfortunately, yes. So, for example, you came here, you contributed for like 10 years, and then you leave the country, you never got a green card, you're not eligible for Social Security or anything, then the answer is yes, it is related. So, you need to make sure that basically the Social Security you need to know what the Social Security, you mean the SSI, right? That's what you wanted to?
What I'm asking is, like, without getting green card, if somebody leaves the country even after 10, 12 years of paying the Social Security.
Yeah, you don't get it. I'm thinking of public charge. You don't get it, unfortunately. They keep the money, and that's why a lot of people got upset, but they don't return it unless maybe one day someone file a lawsuit.
Does the government has any reason to hold that money with them? They don't give it to us. Do they have any grounds for that? I mean, it's our money being deducted and then kept with the government.
Yeah, that's the unfair part, because you never know, but they collect that as part of the payroll, but then to give you back, you have to qualify for it, and since you don't, then it doesn't make any sense. So to tell them no, if I tell you no, they don't have a right, there's no provision there, so I cannot really tell you no, because they have full control over when it comes to Social Security and taxes. So maybe some people can get together and file a lawsuit and class action, but unfortunately the money is stuck with them.
Okay. Well, as of now, there's no provisions, right? So that's what.
No, there's none, unfortunately.
Okay.
Well,
thank you.
Okay, so ladies and gentlemen, thank you so much. We had a lot of callers today, and I wanted to thank you all and tell you that thank you, Vedika, for helping me. Anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our office, 510-742-5887. 510-742-5887. And I think we're almost done now. Amit, are you there? Hello? Hello? Hey, Amit.
Hey, Sean, how are you?
I'm doing well. So, Amit, I'll let you finish, and if you can mention in Punjabi and Hindi about the debt settlement, that would be great. And talk to you guys next week. Thank you so much, and thank you, Vidika, and we'll be back next week, same time. Take care.